We talked about an application process and
Right.
can
So there is an application process and you would have to go see a doctor. The question kind of comes back to what is going to qualify you, especially in the catch-all provision. So Amendment 2, which is now in the Constitution, outlined very specific ailments, but then it also provided this catch-all, which under the current rules, the Florida Board of Medicine is going to have to define what additional ailments qualify. And that's inconsistent with what Amendment 2 said. So, I mean, I personally agree with you. I think it should be between the physician and the patient, and that would be more sensible. The other difference, and the reason for that, I should say, is because if the Florida Board of Medicine is going to just enumerate additional ailments, there are people who have unusual ailments, right, that are only for a very few people that may not come into consideration, but would only come into consideration when talking to their individual physician. And I don't want people, just because they're few in number, to not get the treatment that they need. The second difference that we have here in Florida, as the rules are proposed at this time, is the difference between that horizontal and vertical integration. And some people are concerned that with it organized in this fashion, that people are not going to have the same type of access to cannabis that they need, both because they're afraid that the prices are going to be too high because there's not sufficient competition there, but also because if you happen to live in a small town like I do that is not near a city center, you're going to have to either make a long drive or pay the dispensary to bring it to you. So for people who are having, such significant physical challenges, it is not easy to get, 2.5 hours away to the city to get this medicine.